Así que Andrés, Santiago, les doy la palabra.
Bueno, buenas tardes, gracias Candela, es un placer estar acá para venir a presentar a Krzysztof. La presentación la vamos a hacer en español, pero vamos a decir buenas cosas de Krzysztof en caso que no nos entienda. Krzysztof, we will say your presentation in Spanish, but we promise that we will be accurate with your CV and the good things that we're going to talk about you, okay? Para empezar, algunos comentarios del CV de Krzysztof. Actualmente en su actividad profesional, Krzysztof es secretario jurídico de la Sala Primera de la Abogacía General de la Corte de Justicia de la Unión Europea. Anteriormente se había desarrollado como asistente académico en el marco de los estudios de doctorado en la Facultad de Derecho y Administración de la Universidad de Silesia en Polonia, y en forma previa había sido consultor jurídico del bufete de abogados Franz Conley Sichel de Polonia. Sorry for my pronunciation in Polish. Y de su formación profesional, su formación profesional le hizo un aprendizaje como abogado en la Cámara de Abogados del Distrito, también en Katowice, en Polonia, habiendo completado su admisión en el Colegio de Abogados del Estado en el año 2017 también en Polonia. Y Andrés, no sé si quieres agregar algún elemento más del CV de Krzysztof.
Sí, cómo no. Primero, gracias Santiago, y bueno, buenas tardes a todos. Muchas gracias a todos por estar acá, y en especial a Krzysztof, que se está uniendo a nosotros desde tan lejos. Continuando con el currículum de Krzysztof en lo que es educación, Krzysztof tiene un máster en Derecho de la Universidad de Silesia en Katowice, Polonia, completado con la presentación de una tesis titulada Responsabilidad por daños resultantes del acta Iure Imperi en el Derecho Internacional Privado, preparado bajo la guía del profesor Maximilian Pazdan. Tiene también un posgrado en estudios de Derecho Europeo de la Universidad también de Silesia, completado esta vez con una disertación titulada Derecho Internacional Privado y la jurisdicción en aspectos de la protección de los consumidores en el mercado único europeo de seguros, y preparado bajo la guía de la profesora Mónica Jagielska. También completó el posgrado del programa de Derecho Privado Europeo. Ha completado también estudios doctorales en leyes en la Universidad de Silesia, y finalmente recibió en el año, perdón, no tengo el año, recibió un PhD en Derecho Internacional Privado también de la Universidad de Silesia, otorgado con summa cum laude, con la presentación de una tesis preparada bajo la guía del profesor Maciej Spunar, no puedo decir que estoy ducho en la pronunciación en polaco, y titulado Elección de ley y la protección de terceras partes bajo la regulación de Roma II. Después, en actividades académicas recientes, esto es todo en el año 2019, participó de los últimos casos de la regulación de sucesiones bajo la Corte de Justicia Europea de la Unión Europea. Participó también en un seminario en el Congreso de Derecho Internacional Privado de la Universidad Mikołaj Kopernik en Torun, en Polonia. También fue parte del reporte nacional polaco en el proyecto de investigación Regulación de Bruselas 1A, un estándar para la libre circulación de las sentencias y la cooperación mutua. Y la ocasión en la cual nosotros lo conocimos fue parte del curso de verano de Derecho Internacional Privado de la Academia de Derecho Internacional de La Haya, en el cual se le otorgó el diploma por los Directed Studies, con una mención especial por los resultados de su examen. Y por último, participó en septiembre del año pasado en una conferencia de los principios de un Estado único y el rol en delimitar las leyes aplicables también en Katowice, Polonia. Te cedo la palabra nuevamente a vos, Santiago.
Un poco para llevarlo un poco a Krzysztof más, el Krzysztof más humano, vamos a decir cosas que no están en el CV de Krzysztof, pero que nos gusta compartir con ustedes. Krzysztof, we are going to say some things that are not in your CV, but things that we would like people to know about you. A Krzysztof lo conocimos en el curso de la Academia Internacional de La Haya. Con Candela y él compartimos específicamente los Direct Studies. Krzysztof fue el único alumno de la generación en obtener en dar el examen y obtener el diploma. Y lo que más me impresionaba de estar con Cristian en aquel momento, de compartir con él el curso, ya sea las instancias curriculares y extracurriculares, era su forma y su manera, su pensamiento crítico y global, estando muy abierto no solo a nuevas ideas, sino también a conocer los regímenes jurídicos distintos y cómo cada uno de esos regímenes se comportaban siempre de una mirada muy, muy respetuosa, muy crítica, y que además demostraba muchísimo conocimiento. Así que Krzysztof, my friend, es un placer poder estar presentándote el día de hoy. Andrés.
Bueno, y finalmente decir que una otra cosa que uno puede resaltar de Krzysztof, además de la inteligencia y su brillante carrera académica, que es más que evidente por su currículum, es Krzysztof como persona. Con Santiago, Candela y Lucía tuvimos el gusto de poder compartir el curso de Derecho de la Academia de Derecho Internacional de La Haya, de Derecho Internacional Privado, pero también otra de las cosas que compartimos y creo que es igual o más valiosa fue la presencia de Krzysztof fuera de lo estrictamente académico. Tengo que decir también que, en mi opinión, en un ambiente profesional como es el jurídico, que tiene un componente social muy importante, creo que el don de gente y el querer compartir momentos y interesarse a su vez también por las carreras y las vidas de los colegas de todo el mundo, con la energía y el espíritu envidiable que tiene Krzysztof, es sin duda algo muy destacable. Y bueno, creo que eso quedó más que en evidencia por la ovación que le dio todo el grupo del curso de verano de la academia, cuando recibió el diploma de los Direct Studies, que estoy seguro que no tuvo antecedentes.
Bueno, muchísimas gracias Andrés y Santi. Creo que han reflejado de una manera muy clara lo que esta amistad significa para nosotros, y es para mí hermoso que hoy podamos estar todos compartiendo este gran evento. Bueno, Chris, I would like to welcome you to the Center for Legal and Social Research. We hope that you enjoy giving your lecture today. We are very excited to have you here with us. We believe that this is an excellent opportunity to get in touch with European law and enrich ourselves with your valuable contributions. For that, I would like to thank you. As I have already mentioned, we will now listen to your presentation, and then move on to the Q&A session, where the audience will be able to make contributions as well. So, Chris, the floor is yours.
Thank you very much. I must start by thanking that will be a long part, I must say, because after what I have heard, I'm a little bit breathtaken. So I start first and foremost by expressing my gratitude for this kind invitation, for all the organization effort. Of course, to Candela, my dear friend, thank you very much. I'm delighted because I'm not only among excellent lawyers, but among great friends. And that's very important to think of this, in my case, evening. But I'm really happy. So thanks, Candela. Thanks to Andreas and Santiago, my dear friends. That was a wonderful, breathtaking presentation. I did not merit that, but still, thank you very much. And thank you also to the coordinators and organizers, Virginia, Lucia, Belen, Martina, and Martin. Thank you very much for your effort. I'm also here to listen to you, to listen to your contributions and your commentaries of what I will present. And I'm very much looking forward for the discussion that we will hopefully have after my presentation. Yes, I will just start by, I hope it's visible, the presentation, yes, so I can start.
Please, don't worry.
So as the topic of our seminar, of our session, is, as you can see, this characterization is private international law and its new paradigms, and well, in the context of EU private international law. But as you will see, I will not confine myself only to EU private international law, because in fact, as you will see from this short description of the issues that I want to address, or the short program or plan of this presentation, I will of course start with a brief overview or presentation of EU private international law, say a few words what in general what I mean by characterization, even if these things will be, of course, obvious to you. But next, I will address the question why we should, well, discuss that question if I am talking about EU private international law and where we put it in global context, because we could wonder that maybe if it's European Union private international law, it's an internal affair of European Union and we should not really matter. And on the other hand, the European Union should not really matter what is done when it comes to characterization worldwide in other countries outside of European Union. That will be a spoiler. Of course, I will answer this question that of course, yes, there is a global context to that, and luckily so, because that will allow us to delve into the details of how the characterization within the EU is being done and what are its implications for the EU in the global context and what we can learn from the others, so from the non-member states in relation to characterization and what its role. It might sound a bit cryptic now, but it's done on purpose in order to maybe surprise you later on when within the presentation. So as promised, I will start with this short, brief introduction of EU private international law, what I mean by that and what makes part of that system, because indeed it is a system. That such system, if we use that word, I would say exists within every state that has its set of rules of private international law. And in European Union, it was we went quite a long way to arrive to the state where we are now, because initially, prior to the creation of European Community, because that was the initial name of European Union, it became European Community sometime later. I will get back to this. Every member state had its own rules on jurisdiction, conflict of laws, rules, of course. The core idea of European Community was to unify or at least harmonize legal solutions in the member states. That was the core, the essential idea. And with that idea was linked the institution that exists also nowadays in some international organizations, namely a request for a preliminary ruling. That's a special procedure within which a court of a member state can ask a court of justice, or the ECJ, we may use this abbreviation, to interpret EU law and to give a coherent, uniform interpretation of a certain legal term or legal category that will be applied within all the member states. And while this idea of unification existed from the very start in the European Union, or European Community as it was called back then, private international law was not covered by the unification efforts. Simply because at the very beginning, the European Community did not have competence to regulate private international law. Nevertheless, the necessity or the utility of such unification was seen, as that's the case with international conventions outside of the European Union. So member states decided to act in that regard. And what happened in the lack of a legal basis for any kind of unification on the EU level, several conventions were entered into by member states, and that was the period before the 1999. And here, two very important instruments of EU private international law were created, namely Brussels Convention from '68 and Rome Convention from '80s. As you can see here, I tried to more or less present how it was, what was the scope. So Brussels Convention, that was rules on jurisdiction, contractual, non-contractual obligations in particular, because many other aspects too, while Rome Convention, that's contractual obligations. One thing that's important here, that these conventions were not concluded by European Community. They were concluded by member states, so it was not like a regulation or a directive. That was only the member states who concluded a certain convention. As a consequence, the Court of Justice, or the ECJ, as I mentioned before, did not have competence to interpret these conventions. However, that was rapidly changed, and there were special protocols that allowed the Court of Justice to interpret these conventions too. And that will become soon very, very important. The conventions were so successful that then next in '99, there was a Treaty of Amsterdam. That was a treaty that reformed even more deeply the European Community. And there was created a legal basis for unification of private international law. More specifically, that's in the unification in regards to judicial cooperation in civil and commercial matters having cross-border implications. You will see that this notion that would be a leitmotif of EU private international law or the unification of private international law within Union. And you can see this era of evolution of private international law in Europe spawned the Brussels I regulation that replaced the Brussels Convention and twin regulations, Rome I, Rome II regulations on contractual and contractual obligations, Brussels II bis regulation, maintenance regulation, and very importantly in the context we are discussing today, the Hague Protocol. And here one thing is worth our attention, because I've mentioned before that the Brussels Convention and Rome Convention were concluded by the member states. So the European community was not party to these conventions, while when it comes to the Hague Protocol, not only the member states are the party to the convention, in fact it's a convention, but also European Union. So we have the following situation. The member states are party to a protocol, to the Hague Protocol on the maintenance, law applicable to the maintenance, and also the European Union itself. It is also important because, as we will see later, there are also non-member states who are parties to the protocol. And it will have a very serious implications concerning the characterization. And next, the ultimate final phase, at least so far, that was the Treaty of Lisbon. And important notice, from 1st December 2009, the European Community, so EC, as you may see sometimes this abbreviation, became European Union. And this legal basis for integration was, for unification of private international law was made even more, well, the scope of the integration was made even more wide as a consequence. Well, new instruments were adopted. So that was the Brussels I bis regulation. That was the recast of the Brussels I regulation. The succession regulation that you were discussing some time ago during the session concerning the international successions. That regulation. And as you can see, that era was not only successful, but it also illustrated something quite maybe quite preoccupying for international lawyers, because despite the existence of this vehicle for the unification of private international law, it appears that it's not only the existence of legal instruments, but also the political will that allows to unify private international law. Because while member states agreed on obligations, contractual, non-contractual, maintenance, succession, well, there was no consensus in regards to divorce and legal separation, to matrimonial property regimes, and registered partnership regulation and registered partnerships. And as a consequence, there is a special possibility provided for in the European treaties that allows to regulate something by a regulation, so that instrument that in principle is applicable directly in all the member states, but it allows to adopt a regulation that's applicable only in some member states. Simply said, to simplify it, there were some countries that considered that, for instance, in regards to divorce and legal separation, they are not willing to integrate or to arrive to a certain common point with others, and they stopped. To a certain extent, they blocked the unification of private international law within EU. And as a consequence, a method was used that allows to a certain extent let's say overturn that kind of problem, but simply adopting a regulation that's applicable only in some member states, at least 9 member states. That already shows an important thing, that even within EU, it's not true that the private national law is fully unified and everyone applies the same regulation or the same choice of law rules when it comes to all the areas covered by law. As you can see, there is this slight difference when it comes to the divorce and legal separation, matrimonial property regimes, and registered partnership regulation. And so you can see that within 50 years, a quite complex system was created within the EU of various sources of international law, and its structure is to a certain extent reflected in one provision of Polish law. I found it, and you will find, maybe you don't find it interesting now, but I think you will find it interesting. And looking at this provision, we can more or less create the hierarchy of the legal sources of private international law that are applicable in member states. You can see that this provision is kind of problematic because we need to read it backwards in order to establish that it's first, on the first place, it's EU law, then treaties and conventions, and internal sources. But if we think about it, it's not something that's really surprising because it's very much characteristic to all the systems. Because if we take a look, for instance, at the article I found 2594 of the Argentinian Civil and Commercial Code from 2014, that's, I would say that the Argentinian provision is far better than the Polish one because it's less cryptic and you don't need to read it backwards in order to establish what's the order of the sources of private international law. Because it clearly starts with the treaties and international conventions and then internal sources of private international law. But the system as such is structured in a similar way. Of course, well, there's no EU law, but like the panorama is more or less the same. And now, as we have discussed what the EU private international law is, and we have created some background for the future discussion, we can go further to the issue of characterization, and this is where it becomes far more dynamic than just going back to the historical development of international law. Well, what characterization is? In broader perspective, it's interpretation of the legal concept of or categories of private international law. So we can look at it from one side. We could say that it's we try to determine which choice of law rule from the law of forum needs to be applied to a certain situation or part of that situation to determine which law will govern that situation. So that's a look from one perspective. We could also say, well, if you turn our view, take a different optique, we could say that in fact it's a classification of a situation within a certain legal category. So we have, for instance, two people that agreed on something and wrote it on paper. So we could say, oh, it's a contract, and therefore we will apply a rule that designates a law for applicable to a contractual obligation. And it is true that quite often, at least that's the situation in most European countries, there is a tendency to say that characterization is not typical, is typical to choice of law rules, but is not used in relation to rules on jurisdiction. So that would mean that the characterization is a very particular notion used only in the context of choice of law rules, not in relation to rules on jurisdiction. And while it might be certainly true when it comes to classical traditional approach to private international law, this argument loses a little bit of its impact, of its weight when it comes to EU private international law. Because as we have seen before, the EU legislator more active at least when it comes to rules on jurisdiction. And what's more, he reutilizes the concepts from the rules on jurisdiction in choice of law rules. As I've mentioned, I'll try to just go back to this. As you see quite often, we have, for instance, the Brussels Convention that covers contractual and non-contractual obligations, and then on the Brussels I regulation, and then you have Rome regulations that cover contractual and non-contractual obligations. We have Brussels II bis regulation on divorce and legal separation, and we have, as you can see, this Rome III regulation, divorce and legal separation. So these are the same notions that are being used. And while this is always can be discussed whether a characterization method or interpretation method that is used in relation to rules on jurisdiction can be used in relation to choice of laws rules, in essence, we could say that the European legislator, EU legislator, is trying, or at least putting much emphasis on the coordination in between these domains. As a consequence, we could speak of characterization, and that's already the first particularity of this European order, in relation to rules on jurisdiction. Next. Well, the question arises, as I mentioned before, why we should care, why we should discuss it, why we should present it, and what's the general interest in talking about the characterization in modern days and characterization of European private international law in the global context. outside of EU. And in fact, I would say that while it is quite often stated that EU private international law is not a good example to teach, for instance, or to learn or to examine private international institutions in general, because it has so many particularities, I would, to a certain degree, disagree and say, of course, it is true that EUPL has developed its own toolbox of methods of characterization that we will see in a second. But nevertheless, some of them are very particular for EU law. Some of them are in fact a variation of methods of characterization that are used elsewhere. So in the first place, there is a comparative law interest to see how things are being done in one place to compare to how they're being done in another state or in another international organization. That being said, someone could say, but okay, but regardless, the doctrinal curiosity that would stimulate any kind of comparative research, what is really the interest in examining this characterization of EU private international law from a perspective, for instance, of non-EU lawyer? And I would say that, well, that could be true if EU private international law would be a hermetic system, meaning that it would apply only between member states and regulate situations linked only to the member states. Nevertheless, its ambitions are far more reaching. And just to give you two illustrations of that. First, we have something like that, but that's quite a common rule, that choice of law rules have universal application. That means it's how the EU legislator calls it, but it means that if we have a rule that says that, for instance, law of state of domicile applies to govern a certain issue, and it happens that the domicile of a person in question is, for instance, in Argentina, EU member state court will apply Argentinian law. So that's the first element. But more importantly, similar once again to the requirement that's provided for in Argentinian law concerning the application of rules of jurisdiction. If I'm not wrong, in order for the rules on jurisdiction to apply, according to Article 2594 of the Civil and Commercial Code in Argentina, a situation might be linked to several national legal systems. That's also the case when it comes to the EU. A situation must be international. But what is important, this international character of a situation may result not only from involvement of two or more member states, but of involvement of a member state and a third state. As a consequence, it can happen that two systems of private international law consider themselves well suited to govern a certain question. For instance, it can happen that the EU member state courts do consider that they have jurisdiction and that they will apply their choice of law rules. And it can happen that the situation is in fact more linked to Argentina, and therefore on the basis of Argentina rules on jurisdiction, a court in Argentina will consider that it should hear the case. So of course, there is in such situation, given that there must be a certain tension and conflict between the solutions adopted in these two private international systems, there is of course a certain interest, or I would say interest, in, if not coherence of solutions, at least a certain coordination. And what's more, finally, there's also quite often nowadays a question is asked how private international law should answer the question of globalization. And quite recently, a book was published, and I think that it will illustrate clearly, a quotation from that book will illustrate clearly why we would need that kind of, let's say, global approach towards characterization and looking at it from a larger perspective. Because nowadays, with the issues such as, well, internet, global corporations, environment, let's say, watered down borderline between public and private international law, more and more areas have to be addressed in a different way. It's a very interesting concept that's being presented under this title, Global Private International Law, and we really can see that characterization can play an important role in that context if it's being done with this idea of being global and not only confined to a certain area. And therefore, that's the reason why the methods of characterization in different states or in different international organizations are worth of our attention. So I hopefully convinced you that it's important to look at the characterization, how it's being done in EU, and EU has to look how it's being done elsewhere. So now we can go further and discuss what give you just maybe more details or just mark few issues that might be problematic and that could stimulate our discussion. As you know, according to the main theories, there are, let's say, three. I know that most probably you could name more, but let's say there are three main methods of characterization. The first one would be, of course, according to the law of the forum, according to the law applicable to a certain situation, scenario, that could be a question of discussion, and so-called autonomous characterization. Quite rarely, the Private International Act specifies the method of characterization that should be adopted when it comes to application of its provision. Among notable exceptions, we could mention, for instance, the Bustamante Code, and here it was clearly a provision that pronounced itself in favor of lex fori interpretation, and then we had, for instance, another example, but that's not the first act of European private international law. I mentioned in the very beginning that was something that came later on. And here it was more or less clear that they were striving for uniform interpretation. But nevertheless, as you have seen in the very beginning, the very first act, the very fundament of EU private international law, that was the Brussels Convention from '68. And this convention did not contain any provision that would address the issue of characterization. And maybe luckily so, because I would argue that, in fact, the absence of a clear provision paved the way to the autonomous characterization as we know it now under EU private international law. You remember I've mentioned that there is this special procedure when the courts of the member states may ask Court of Justice to interpret a certain provision of EU law, and that it would give a ruling saying how we should understand a certain notion. And it indeed happened within EU in relation to the Brussels Convention that Court of a member state, in fact of Germany, asked the Court of Justice to interpret the notion of civil and commercial matter. So that is a notion that defines in fact the scope of the EU private international law in essence, as opposed to public law. That means that, well, it's private, so it's covered by EU private international law. And the case was quite simple. There was a company in Belgium that received a judgment and wanted to enforce it in Germany, and the German court was asking whether the case is civil or commercial. That was in essence that. And the court asked whether it should consider that it's the Belgian law that applies, so the law of the state when the judgment was delivered, or Germany where the judgment is to be enforced. And in fact, the Court of Justice answered that neither of these solutions is correct because we should adopt a uniform interpretation. With that being said, it's not true that the autonomous characterization that was something inherent for the EU private international law, because back in the 70s, a very successful convention was adopted was established within the Hague Conference on Private International Law. That was the Hague Traffic Accidents Convention that you can see there. So before we had this judgment concerning the convention from '68, and the judgment was adopted in '76. And then we had the convention adopted within the auspices of the Hague Conference on Private International Law. And here, the drafters of the convention clearly state in the explanatory report, they do not specify what method of characterization should be adopted, and they presume that the characterization therefore will be affected by the law of the forum, so the lex fori. So you can see that it was already quite a groundbreaking moment to say something that important in the late 70s, that will be autonomous characterization. And how successful it can seem, as we will see, the autonomous characterization does not always mean the same thing and did not mean the same thing as it means now. And it will allow us to see what methods were adopted and where we are now and where are the new trends and where the court is going. And finally, in the very end, I will address the question, what are the implications of that in the global context? It is true that within the last 50 years, most of the judgments of the Court of Justice that concerned private international law used the notion autonomous interpretation. Nevertheless, we could try to divide the period of 50 years into 3 phases where a little bit different methods were adopted. Of course, as was the development of European private international law evolution rather than a revolution, so was with the characterization in the context of EU PIL, it was also of evolutionary nature. So we could conventionally say that the start of the autonomous characterization, the beginning, was the Eurocontrol judgment. So the one I've mentioned before concerning this Belgian-German situation. And things were not so simple as to say that once it was established that the interpretation is autonomous, it was already clear for that. And since 50 years, it's all the same. Because initially, the Court of Justice was sort of reluctant to say that in each case, such an autonomous characterization must apply. It was stating, as you can see from the judgment from '86, that more or less we need to assess on a case-by-case basis whether we prefer an autonomous characterization in relation to a single provision should be adopted, or it should be characterized by the method of characterization according to Lex Fori. But as I've mentioned, the evolutionary nature of this characterization, what happened even a few years later and was finally crystallized in the judgment I will show you just in an instant, like this, the approach was completely shifted, because from being something that could be applied on a case-by-case basis, it became a default mode. So as you see from this judgment in case Nikiforidis, what the court is saying now is you need to proceed to an autonomous characterization unless there is a clear provision that says no, that you should not be doing this. So you already see how it evolved from being something that was quite surprising in the very beginning, adopted, were used on a case-by-case basis, and then finally something that became a default rule of interpretation. But that's not the end of it, because there's also this evolution went also in the different can be observed also on the different level. Namely, once again, going back to the judgment that started all this adventure of autonomous characterization, you can see here a piece, a sentence from the judgment where it is being said that, well, in order to have an autonomous characterization, we must delve into comparative research to see how a certain notion is understood in national legal systems, and that phrase to a certain extent reflects the idea that I would say of a pure autonomous characterization. That means that we are not overburdened by a meaning of a certain term in one international law, but what we do, we look globally. Like I would say, there are some, maybe it's not me, but there are some authors who say that, well, we should look how worldwide or in all civilized nations, how a certain notion is understood. But shortly after, in '76, we were talking about the corpus of the national legal systems and understanding of certain notions. The Court of Justice started to say that it's not the body of law of all the nations or something that's global or international, truly international. It's the body of law of member states, and it's all contracting states. So in fact, this research, comparative research that is being done for the purposes of autonomous characterization was limited to only to the member states. So you see already in this first phase that if we compare it to the idea of the pure or the autonomous characterization in its pure form, first we start from case-by-case application, and then it becomes a default method of interpretation. And more importantly, maybe it starts as a result or understanding of certain notions as they are understood everywhere, to understanding certain notions as they are understood in the member states of Union. So you see a gradual, let's say, departure from the autonomous characterization in its purest form. But that was not the end of it yet, because then came the second phase. And here it was not only about us being sure that there is a coherence with the national legal solutions, but rather a coherence with EU law. And once again, it was a phase of evolutionary nature, because in the very beginning, it was rather the coherence between the EU private international law rules on jurisdiction, for instance, this Brussels Convention I mentioned before, and choice of law rules. So as we were talking about before, that there are the same terms are being used in provisions of instruments on jurisdiction and in instruments on law applicable. And therefore, what happened in this phase, there was an emphasis on coordination of the meanings of these terms. But once again, from something that seemed quite natural to private international law in general, a new development surfaced, and the court started to interpret some notions of private international law in relation to EU law. So not to relation to the national laws of the member states, but in relation to purely international to EU law. And that you can see examples here, how it was being done, not to go into many details. Just what is important is the shift of the emphasis from coordination with national law to coordination with EU law already in the second phase. And the third phase, and the last one, I think that is the most controversial development. That is the phase that a new element is injected into the characterization. Namely, it's not only about the consistency or coherence with the legal system or international legal order, but rather the idea that the characterizations must ensure the effectiveness of some provisions. Here, there was a question, there was a case that considered, in fact, the succession regulation I've mentioned in the very beginning. And the question was whether, you can see the provision on the screen, whether a share that is attributed to a surviving spouse on the basis of this German provision should receive a classification as a succession matter, or it's something that falls within matrimonial property regime. Well, you can see the provision. You can answer by yourself what would be your opinion on that. It's important to know that there was it was really the debate that lasted in Germany for years, and there was no clear solution until 3 years before, when it was said that it's in fact the matrimonial property regimes, but in this case, the EU private international law rules were not applicable ratione temporis. But the Court of Justice, in its judgment, ruled that this share that's attributed to the surviving spouse is in fact a succession matter. And one of the arguments was that, well, if we classify it as the succession matter, that means that it can be shown in the certificate of succession that's created on the EU level, and therefore that certificate will be effective. So as you can see, in fact, what the court is trying to do, it's saying that we should characterize notions of private international law in order to guarantee the effectiveness of EU law and not effectiveness of choice of laws, rules, or jurisdictional rules. A very different rules of EU law as such. So not all rules on private international law. And what that gives in the global context, that's just a short description. That in global context, I've mentioned at the very beginning. The question, like, if the EU private international law is a truly international law, and what can be learned from that. And in this regard, I will return to the Hague Protocol I mentioned before. So that's the protocol, once again, adopted, drafted within the Hague Conference on Private International Law. And I mentioned before that it's the EU who's member to it, member states, but it's also non-member states like Brazil. And that's a very interesting question. What should happen if, for instance, one of the courts of the member states asks the Court of Justice to interpret a certain notion of the Hague Protocol because the EU is the member state to that protocol. That means that the Court of Justice can interpret that protocol, and it, of course, it will do it, and the judgment that it will render will be binding to the member states. The question remains, what and if there is any impact of that judgment towards Brazil, because Brazil, of course, is not a member state, is not being bound by the decision of the Court of Justice. And that's a very controversial question that we, in fact, it's not only a theoretical one, because the Court of Justice already had an occasion to interpret the Hague Protocol, and so it did. And interestingly, that opened space for a true debate, because I don't want to go into much details, just to illustrate the problem here. There was a question concerning a certain notion, it's being interpreted, and what the court is doing is saying that, of course, it's not only the wording of the notion that is interpreting that's important, it's the context and the objectives, so it's not something that's too controversial. Then, of course, preparatory work, so we would say to see the reports of how the act was drafted, and then it proceeds to make an argument related to the EU maintenance regulation. Like you remember from this initial screen that the instruments on jurisdiction are completed by the instruments on the law applicable. And here the instrument on law applicable, that's the Hague Protocol, so an international convention on the one hand, and on the other hand, the court is, well, interpreting it in the light of the rules on jurisdiction of the EU maintenance regulation that, of course, does not apply in Brazil. And the question is, therefore, what is the impact, or what could be the impact of that judgment rendered by the Court of Justice that, once again, is binding, of course, to the member states. It's not binding, obviously, to Brazil. What should be the stance of Brazil in that regards? Whether it has any impact, whether the inclusion of these links to EU maintenance regulation in the argumentation renders it not useful or redundant, or it's in fact stopping to a certain extent, well, let's say, the very purpose of an Hague Protocol, that's an international convention opened also not to member states. But likely, I would think that we can answer this question maybe not in a we can see the situation not in such a bad shades, because if we look at the Vienna Convention on the Law of Treaties that would establish how we should interpret international law, and for instance the Hague Protocol, we'll see that it's not very different what the Court of Justice has done with this reference, not only to the wording, to the objectives, to the context, to the preparatory work. And of course, that's the problematic question, what happens with the context of this EU regulation? Still, we see that the Article 31 allows to do that. The question is just whether Brazil should adopt or should follow in its argumentation in different judgments, should take into account what the Court of Justice is saying. And in order to answer that question, or to give my take on that question, I would propose to have a look at a different problem that exists and was addressed quite recently, but it's a similar problem, but a different scenario. Namely, that's an interaction between EU private international and public international law. And that was simply a question about the articulation between the EU private international and the immunity from jurisdiction, like the customary immunity from jurisdiction, because as you can see, a notion taken clearly from public international law, the Acta Iure Impedi, was introduced in EU private international regulation to define its scope. And here, what is important is that the Court of Justice proceeded to interpret public international law. It's not, of course, EU law, but it said that, well, it can affect EU law. Therefore, as we are competent to interpret EU law, we will interpret public international, but respecting its principles, unless they do not violate the very important, the very values on which the EU is bound. And I think that this solution, when it comes to what's the impact of the EU private international law and its characterization outside of EU, so in the global context, I would argue that maybe that could be the similar approach, like mirroring what I've mentioned before. Mainly, well, we all try to find a coherent solution to an understanding of certain notions, and we do it to the maximal extent possible, unless there is a certain policy or a certain interest or a certain value that's very important for a certain state or international organization that does not allow to do so. In that scenario, well, we could justify a different understanding, a different meaning of a certain term. And while it's not an ideal solution, because the ideal one that would be having a global international, private international law applicable worldwide, that could be also that could be at least a certain small step towards bigger integration, bigger unification, and therefore easier solving of the problems, as I mentioned before, and caused by, for instance, internet, global corporations, and all these issues that arise due to the to the arise in modernized world and are caused or are effect of the globalization. And I think that with that, I'm running out of time, and I will thank you very much for your attention. I'm looking forward for all your questions or discussions that we might have. And I also remain at your disposal outside of the frame of the seminar. You will easily find my contacts. Thanks to Candela, who announced so kindly on different profiles and social media the seminar, for which I'm very thankful. And I'm very much looking forward for your questions or commentaries or critiques. Thank you very much.
Thank you, Chris. You have enlightened us about European law, and just as I have previously remarked, the importance of the study of comparative law has in legal research. That was an insightful presentation. Thank you very much for sharing your knowledge with us. We will now open the floor for any questions, comments, and contributions the audience may have. So, Lucía.
Thank you, Chris, very much. Now we are going to open Santiago's microphone.
Thank you. Thank you, Chris. It was really a pleasure Krzysztof, to hear you and know about your insight in this topic. Moreover, when we are thinking about EU law from our perspective here in Uruguay and Argentina as well. Just one question I was thinking when you start your presentation talking about international cooperation, and then related with your aspect about characterization. Do you think that I wrote the question in the chat, but do you think that the current Brexit situation with the UK will affect the status of international cooperation within the EU framework and the advance of obtaining in the different judgment that you mentioned in matter of characterization and international cooperation as well? I know that Brexit is a new thing, but, not so new. But
that's a very interesting question, and in fact, I think, but that's my guess. If that will be a longer answer, if I may, because prior to participation of Great Britain, of United Kingdom in EU, they had quite a lot of different concepts when it comes to characterization compared to continental member states. Just to give you an example, for instance, the statutes of limitation, the period within which you can, for instance, introduce an action to the court, they considered that that's a procedural nature of it. So it was not falling within the law applicable as governed by the choice of law rules. They were considering that it's a procedural thing, and as a consequence, it's not like choice of laws who decide which law applies. Then they entered into the European community back then, and what happened is that quite often they were not participating in, because there is such a possibility, because joining EU, they asked for a certain caveat or certain limitation that they will be not forced to participate in all the instruments of private international law. But nevertheless, they tried their best to use the characterization or the understanding of certain notions as was used in continental Europe. And in relation to Brexit and specifically characterization, I don't think that they will go back. Meaning that, for instance, if they now consider that the statutes of limitation are more of substantive nature, I don't think that they will go back. But I understand your question that the bigger problem that you see is that, well, for instance, the enforcement of judgments, the recognition, and so on and so forth. And of course, that will be a problem unless a certain solution will be created. For now, let's say we are in a situation of a certain, let's say, certain transitory phase, because until the end of that year, the UK is still applying the EU private international law as we have discussed it today. But next year they won't. There are a few ideas what will happen in this field. One of the main concepts being discussed now is whether the instruments developed by the Hague Conference on Private International Law could not be used in that regard. That's the one scenario. The other is, well, a certain agreement, international convention only between EU and the United Kingdom. It's hard to make a guess because, of course, it's a political decision what will happen. But I must say I would be quite happy to see the instruments of the Hague Conference being used in that regard, frankly speaking. If it answers your question, thank you.
Thanks. Thank you, Chris. Thank you, Chris. Now
yes,
we are going to some questions that the assistants are making in the chat. Brian Ortman asked about considering the last UA-Mercosur trade agreement that took place and its continuous discussions within those international organizations. How do you think this will impact in the notion of jurisdictions and competence when facing private international conflict between EU state members and Mercosur state members?
Thank you very much for this question. That was one that I could have expected, and I'm very lucky that there was quite a recent judgment, the one I've mentioned on the public international law, even though it does not consider an international organization, but there was a different one. It was Supreme Site. I can contact later on Brian Ortman to transfer him the link to that judgment. But what we can infer from that most probably from what I've mentioned, the EU will, because the question is what will be the impact. I think that the EU will look into the solutions that are applied within Mercosur in order to not create additional tensions or create any kind of tensions. So there will be this comparative look in that, unless and they will be favorable to, they will do everything to limit any kind of, let's say, conflicts, unless there will be a strong interest or policy in certain areas or in regards to certain issues. And they will argue most probably that these are the EU values that do not allow us to adopt a certain interpretation or reasoning, despite the fact that it's something that's being adopted within Mercosur. Why I'm saying that? Because most probably the problem will be taken out of the issue of characterization, and it will be framed as a question of the hierarchy of the sources of law. And because if it is being done, it appears that we will have an international agreement, we have EU law. The question would be which most notably EU private international law. The question would be which one prevails. And on general basis, that would be the trade agreement that should prevail. And therefore, in order not to adopt the solutions from this or favorable from this trade agreement or favorable to this trade argument, you would need to have to use the argument from the values that are so important for the EU law, like those the fundamental principles that are in the charter, for instance. That's let's say the like human rights related arguments or interests of union related arguments. So in short, I think that there will be a certain openness in limiting any kind of conflicts, so trying to facilitate the trade and the communication. But unless there will be a certain area or a certain problematic, delicate policy that would need it to be taken into account, and in order to, because I understand that's your question, preserve a certain interest of EU. If that addresses your question correctly.
Thank you very much, Chris. The next question is from Mercedes Albornoz, who asked, don't you think that we could also talk about characterization of jurisdiction rules outside the framework of EU law?
Frankly speaking, my answer is yes. I'm very much in favor of using the notion of characterization in relation to rules on jurisdiction. My argument would be that quite often the terminology is similar and the construction of a rule on jurisdiction is somewhat similar to a rule on applicable law, to choice of law rule. The problem results a little bit from my background, because as I was educated, you would need to tell me what's the situation in Argentina. But this reluctance within EU to use the term characterization in relation to rules on jurisdiction results to a certain extent from how the private international law is taught in the universities, because in Poland, in Germany, so at least in these countries, the choice of law rules are taught within the course on private international law, while the rules on jurisdiction are taught within the courses on international procedure or civil procedure. And therefore, these are two different, let's say, bodies of academics who work on that. So that, to a certain extent, I think, rendered or petrified, regardless, of course, the differences that exist between the conflicts of law rules and the characterization. Of course, I understand the discussion on that, but answering your questions, I would say that yes, that notion could be used, but my, let's say, hesitant approach is probably result of my background and of the fact that I have some friends of mine who are also working in academia, who would allergically react to the statement that characterization is conducted in relation to rules on jurisdiction.
Okay, so clear, thank you. The next question is from Professor Pablo Martorati, who asked, what is your opinion about the dispute settlement system of the Mercosur EU agreement?
Well, I must say I don't know so many details about that, frankly speaking. From what I can recall by now, well, the question is one thing that is, I would say, sort of, I don't want to say preoccupying, but what I could more or less be thinking of now, and it also relates to a certain extent to the question of Brian Ortman, whether it will not happen like it happened before in the past in relation to United Nations, relation between United Nations, excuse me, and EU, when at a certain space in the judgment Cadi, that's a famous judgment, they did oppose the solutions of this international organization, of the conventions agreements that were made within United Nations. So when it comes to this settlement system, I would need to know more about it. But the thing that I would be only looking at is whether there won't be a similar solution, namely that if something, despite of how system effective is, at certain stage, someone will not say that it's not going to respect it because it violates some kind of super values that are more important of a certain legal order. I'm afraid that's all I could say in reaction to your question.
Perfect, thank you. Now we are going to open Andres' microphone. We're going to do a question too.
Yes, first of all, Krzysztof, I wanted to thank you. It was a great presentation. My question has to do with the way that the EU has handled or aims to handle the issue of the uniformization of the characterization criteria with regards to EU candidates, and if this is if adapting to the characterization criteria is an issue which is a requirement for admission into the EU, or if it's not, should it be?
When it comes to the whether it's a requirement, I would say that if a state will join union, it will, in principle, apply the EU private international instruments as interpreted by the Court of Justice. As a consequence, it will have to abide to the characterization that exists or is being used within EU private international law. But I've mentioned before, thanks to question of Santiago, the fact that United Kingdom, when they were entering union, negotiated that they won't participate to the whole extent in the unification of private international law. So it could happen that a future member state does the same thing, argues that I don't want to participate in the unification of private international law. The question would be, of course, whether it would happen, because, well, when United Kingdom negotiated that was 40 years ago nearly, and they had a little bit different position compared to other member states. So formally, it's not a requirement, but I would say that politically, most probably it'd be considered as such that you would need to participate in the unification of EU private international law. Situation was quite similar, for instance, with Denmark, who also had such a reserve, such a caveat like United Kingdom, not to unify, but nevertheless, quite often what they did is, regardless of the fact that they could have not, or they renounced to unify their private international law, they did it. They did it voluntarily. A few years, for instance, after adoption of a regulation, they adopted the same solutions on the national level. And when it comes to the first part of your question, if I may, this uniformization policy, that's something, a quite interesting phenomenon, situation that we can observe in Europe and not in EU, because there are some countries that adopt the solutions of EU private international law, more or less. This is taken word by word. I can give you an example, for instance, something I researched some time ago. But for instance, in Serbia, they have adopted I've mentioned before the Rome II regulation. So that's the regulation on the law applicable to non-contractual obligations. And they took exactly the same provisions. Of course, some of them do differ, but they took that and used that in their system of private international law. So while the EU is not it's not, of course, for saying that everyone should adopt their solutions, because why should they? There are some states that do this in order to, let's say, coordinate their system of private international law with the system of EU. That's Serbia. That would be one example I could think of. If that answers your
yes, of course. Thank you very much.
Your question. Thank you.
Thank you, Chris, very much. Very clear your conference and your answer. I think there are no more questions or comments, so thank you very much.
Thank you very much. It was really thank you very much for all the questions, for all the participants, and once again for the organizers and the coordinators, Candela, Andreas, Santiago. Thank you very much, and of course for the coordinators. Thank you very much for all your effort and for this wonderful time I spent with you. But I see a question, if I may. I would not like to.
Yes.
Yes, of course.
Now, Professor Vera Villegas Liquidato is doing a question and speaking in terms of EU international private law, what could be the next step in the work of harmonization? What are the works that are doing now?
So, well, I would, if I may first, I answer the question by saying what I would wish that to be a step. I would hope that these regulations that are adopted within enhanced cooperation, so those that concern divorce, legal separation, matrimonial property regimes, and registered partnerships, that they would be adopted by more member states, because at this stage, there are 18 member states that participate in each of these regulations. So that most probably would be something that would be very much favorably seen by lots of EU citizens. Now, when it comes to the question, what could be the next step, so what area could be covered next, there is an ongoing project, but it was started, in fact, with this Rome 1 regulation I've mentioned before. And in fact, it concerns the property law and assignment. So the legal consequences, who's the owner, and who's not only on the obligation, but the real rights, so droit réel of the within the EU, so the property or ownership. That is something that could be most probably the next step if we want to have a further unification in these areas covered by enhanced cooperation. And more importantly, there's a big emphasis on the regulation of the internet. But here, the solutions are not those of traditional, I would say, well, traditionally seen private international law. It's less of discussion on, for instance, rules on jurisdiction, rather the question of the territorial scope of the decision that are adopted by authorities in member states in relation to internet-related issues. That could be, for just to give you an example, that's the data protection. This is something that they are still, even though there's quite a new regulation working on, an new e-commerce directive or regulation, and that concerns the issues I have mentioned. So this is the ongoing endeavors. So I would say the property law and internet, that is what is being done these days. But they're working on, of course. Thank you very much for your comment and for your question.
Thank you, Chris. Well, now I think that there are no more questions.
Perfect. Thank you, Lucia. We have had a lot of questions and a great Q&A session. So thank you very much, Chris. We really appreciate your insights, your words, and we have enjoyed a lot. On behalf of the audience, we thank you very much. So, para la próxima sesión, a todos los que nos han acompañado, les agradecemos, los invitamos nuevamente que nos volvamos a encontrar el próximo viernes, que vamos a tener la participación del doctor Silvio Batelo Calderón, que nos va a hablar sobre la utilización de las nuevas tecnologías para los casos prácticos de Derecho Internacional Privado. Los esperamos el próximo viernes y gracias nuevamente a todos por participar.
thank you very much again for everyone for the participation. Thank you.
Bye, Chris.
Thank you. It was great to see you.
Great to see you again, Chris. Bye.
Great to see you. Thanks. Thanks for the question. That was very interesting. A very challenging one too.
Yeah, thank you for the answer.